Good morning, dear friends. Today we are going to discuss a very interesting topic of the English common law, which has been borrowed in India also. The principle is the principle of the res gestae. What is it is, and what is the role of this principle in Indian Evidence Act. Dear friends, as you know, the basic unit for Evidence Act is a fact, because evidence can be given of a fact. So we need to understand first what the fact is. If we look at the definition of fact under section 3 of the Indian Evidence Act, it says anything, state of thing, relation of things capable of being perceived by senses. So whatever can be perceived by the senses is a fact. It means an opinion which can never be perceived by the senses can never be a fact. So an opinion, evidence of the opinion is not permissible. Otherwise also, a fact can be, evidence can be given by the person who himself has perceived the fact by his own senses, not by the senses of others. So evidence of a fact which has been experienced by Mr. X. So evidence can only be given by Mr. X only, not by Mr. Y, on the ground that X narrated his experience of this fact to the Y or Z, third person. So it is called the hearsay evidence, and hearsay evidence is not permissible under the Indian Evidence Act in view of section 3. So now coming back to the topic, res gestae. Res gestae, need to be addressed. A very famous case of Rattan versus Queen in England. What happened in that case? Because our Indian Evidence Act has been incorporated on the basis of the English common law. The English common law, the law which developed in English courts. So in Rattan versus Queen, what happened? Since it was the 18th century case, so at that point of time the phones were available, landline phones were available in the Britain, and first a caller needed to call the operator and then ask for a particular number or the particular person to be connected. One day what happened, a lady called to the operator, and the words said by this lady was that, please get me connected to the police. Please get me connected to the police. The caller, before connected the call to the police, noted down the address also from where she was calling, and before the police could be connected to the caller lady, the phone was dropped. Then on the given address, the police reached and found that a woman was dead body of a woman. When the trial was held in the court, the question before the jury arose that whether these words spoken by the woman, that get me connected the police, would be admissible, because she was in distress at that point of time. She was already injured. The court held that since she was asking to get his call connected to the police under distress, she had already been injured, as was established by the other facts also. So the words spoken by her would be relevant, and the evidence can be given of such fact, and the prosecution was permitted to bring this fact as and prove this fact through the operator who really listened this lady. So it is a famous case of Rattan versus Kuhn. So the principle which can be deduced from this case law was merely that anything which the victim or the accused or the witness, whatever they are doing at a particular point of time, for example, a commission of the crime, so all this will be relevant as res gestae. Whatever is said by the accused, whatever is said by the victim, whatever is said by the witnesses too. Suppose A runs to fire at B, and by saying that I will kill you, so and B escapes and tries to save himself, saying save me. So these words would be relevant as res gestae and would be admissible. Why res gestae? Because the act is accompanied with this oral statement, and principle of the separability would apply, and it is to be seen whether the act can be separated from the oral statements. The question would obviously be no. In that case, this fact means his conduct, whatever they have done, and whatever they have said would be admissible as part of the res gestae, because they have the things have been done or said in the course of one transaction. The principle of the one transaction would apply. One transaction would further say that the act and the oral statement would be contemporaneous. There should not be a gap. If one fact in issue means question is whether A killed B or not. If the act of the killing, the transaction of killing of B by A is over, and there is an interval gap, and then whatever is said and done by the others would not be relevant as res gestae, may be relevant under other sections, may be relevant under section 8 of the Indian Evidence Act, where the previous and the post conduct is relevant, but that to the parties, limited to the conduct of the parties. But here under principle of res gestae, the conduct of not only the accused, victim, but also the strangers, third party, would be relevant. Honorable Supreme Court so many times have occasions to comment on this beautiful principle of the res gestae, and said that there must be spontaneous and the simultaneous act, and the utterance or the word should be there, oral statement should be there. No gap should be there. If there is a time gap, interval, principle and acts can be separated from the oral statement, then would not be admissible in 1999, Sukhar versus State of UP, the Supreme Court again followed this landmark judgment of the Rattan versus Queen, and observed that section 6 of the Evidence Act is an exception to the general rule that the hearsay evidence is not admissible. The basic test applied to know whether the act, the fact, the evidence of which is to be given is part of the res gestae or not, to see whether what is the transaction. Transaction would further facilitate what is the fact in issue, and if any fact is so closely and deeply connected with the fact in issue that it cannot be separated, then the evidence of such facts would also be relevant as part of the res gestae. Hope you might have enjoyed it. Thank you.